Hello everyone, welcome back to our YouTube channel. Today we are diving into a fascinating patent litigation case between Indian Institute of Technology Madras versus Controller of Patents and Designs. The case overview is this case was an appeal under section 117A of the Patent Act 1970. The citation is 2024 MHC 2264 and it was heard by Honorable Mr. Justice Senthil Kumar Ramamurthy. The appellant was IIT Madras. So, the fact of the case is IIT Madras challenged the rejection of their patent application titled Method of Doping Potassium into Ammonium Perchlorate. The court examined four key legal issues ranging from frivolity to industrial applicability. So let's look at the timeline. Patent filed in September 2013, published in December 2015, first examination report in April 2019, rejected in April 2020, appeal filed in 2023, and judgment delivered in June 2024. So, this long journey highlights the complexity and procedural rigor of patent prosecution. The below are the court examined about legal issues. These are the legal issues. So coming to the first issue, was the invention frivolously rejected without procedural compliance? So talking about the legal provision of Section 3, Clause A of Patent Act 1970, which excludes frivolous inventions. So IIT Madras argued that this objection was raised only in the final order and without giving prior notice or an opportunity to respond, thereby it violating the natural justice principle. And the controller claimed it was discussed during the hearing and the appellant had the opportunity to respond, but the court found no mention in the examination report or hearing notice about any such objections. So the court held that the raising such a fundamental objection at a final stage without prior notice contravenes the provisions of Section 14, which we read with Section 80 of the Patent Act, which mandate fair opportunity. So the court concluded and said procedure violations there. The rejection under Section 3 Clause A was invalidated. So coming to the next issue, whether it was merely a new form or use of known substance under Section 3 Clause D. So IIT Madras claimed their product had improved thermal properties and burn rates. But the controller cited prior art, specifically US Patent 3269879, and argued no enhanced efficacy was shown. So the court examined and agreed with this, and the invention lacked novelty and efficacy. This was court analysis, and the rejection under Section 3, Clause D was upheld. Now, coming to the next issue, inventive step under Section 2, subsection 1, Clause JA, the third issue. So, IIT Madras emphasized the novel use of filtering material and the absence of external reagents. And court that controller argued these steps were obvious to a skilled chemist. By using the windsurfing test, the court found no surprising technical effect or ingenuity. And the four steps of windsurfing are given in the slide. So you can see identify the notional person skilled in the art. Clause B is identify the relevant common general knowledge of that person. Identify the inventive concept of the claim in question, or if that cannot readily be done, construe it. Third is identify what, if any, differences exist between the matter cited as forming part of the state of the art and the inventive concept of the claim, or the claim was construed. Fourth was reviewed without any knowledge of the alleged invention as claimed. Do those differences constitute steps which would have been obvious to the person skilled in the art, or do they require any degree or invention? So after analyzing these tests, the court found that rejection under Section 2, subsection 1, Clause JA was sustained. Now coming to the last issue, finally, with the fourth issue, industrial applicability under Section 2.1, subclause JA. IIT Madras argued the process was scalable and had a clear utility. The controller raised concern about practicality, frequent filter changes, and drying time. But court clarified practicality is not the test. If the process can be applied industrially, it qualifies. So the rejection under section 2, subsection 1, clause JA was overturned. So the court relied on several key precedents like human genome science versus Eli Lilly for industrial applicability, windsurfing versus tabor marine for inventive step, Pozzoli versus BDMO, refined obviousness analysis, rodeo operations versus assistant controller 2024 for PSITA standard in India. So these cases shaped the court's reasoning and reinforced the standards of patentability. So, what was the outcome of the case was the court upheld the rejection under section 3, clause D, and section 2, subsection 1, clause JA. However, it allowed the appeal in part, acknowledging procedural unfairness under section 3, clause A. Ultimately, the patent application was dismissed. But the conclusion, the take home message was for everyone we should have to do the thorough prior art search. And the IIT Madras experience shows that rigorous investigation and understanding of existing landscape can prevent disappointment and wasted efforts. So, evidence is everything. If you claim novelty or greater efficacy, back it up with the experiment, data, and comparison to prior art. Rest, procedural fairness is non negotiable. With this, these are the references. So, thank you so much for watching. See you in the next video.